Welcome back, everybody, to the Jim Rathman Show. I am your host, Jim Rathman. Before we get started today, just a quick little shout out to our partners, Podgo, who's providing you this amazing content, and Hi Hello Labs in Orlando, Florida, where I'm in-house here. They do an amazing job with all the editing and providing you this amazing content. All right, let's get started. So we have talked about the Melanie Curtin case. We did 3 parts. However, I want to bring you a part 4. The reason I'm going to bring you a part 4 is I really want to break down what happened with the appellate court and why Melanie's case was completely thrown out to where she either charges are dropped or she gets a new trial. What were the reasons for that? Also go into what the Louisiana Supreme Court and what they decided, and then catch you up to speed of what happened with the trial that was just supposed to take place here in mid-November. That trial did not take place. It got pushed back. There were a bunch of writs that went back and forth about what could be allowed in as evidence and what would not be allowed in as evidence. So without further ado, I would like to get started with this because I think it's very important information for you guys to know, especially with trying to dissect this case and not have bias to it. Like, these are the facts. And so I'm going to break it down for you. So here we go. In October, it was October 5th of 2023, Melanie Curtin, her case was thrown out. The First Circuit of Appeals there in Louisiana decided that there was circumstances that should never have been allowed to have happened in her trial. There were 7 specific incidents that happened in her trial, whether you want to say it was abuse of the judge's authority or if it was a stretch, however you want to put that. The bottom line is that it was not seen very favorable to the appellate courts because it showed prejudice towards Melanie. So by those 7, this is what I'm talking about. Okay. First and foremost, they did not allow in the internet search history. Okay. Denny's internet search history was compelling. There was so much evidence within it, whether it was searching for, he had a fetish, right? His fetish was like basically unconscious. I don't want to go as far as to say necrophiliac, but something along those lines, right? The person is unconscious. There was significant amount of role playing, right? He engaged in this kind of activity with his wife at the time, which we refer to as victim and wife number 2. Okay. That wasn't allowed in. The evidence that showed all the photos, the videos of Denny and his wife at the time, the fact that she's consented to all of this sexual content between the two of them, none of that was allowed in. The point to that is because you got to keep in mind, when this video, this 17-minute video that was shown to the jury, is what got Melanie convicted the first time. In that 17-minute video, you know that it wasn't like the video showed how they met up, what led up to it, whether it's somebody taking drugs, not taking drugs, whatever the case might be. You see none of that. The video starts with them fully engaged in sexual activity. They are involved in what I believe is a role-playing threesome. That's where it starts. So who consented? It's really hard to say if the victim, wife number 2, consented or not. Her face was covered. It was covered the entire time. It's not like you can see if her eyes are open or her eyes closed. What was going on other than the fact that her face was covered? But what you can see throughout that video, and there are moments of it, according to the juror that actually saw the video, all right, juror number 3 said you could actually see because Melanie Curtin had fingernail polish on. Her fingernails were painted, and victim, wife number 2, did not. And you could distinguish whose hand is whose. There were times that she is fondling her husband's testicles, grabbing his penis and reinserting him back into her. She's sexually arousing herself during this time. She even goes as far as to rub her hands and rub through Melanie's hair. All that is on the video. But again, her face is covered. Don't you think it would be important for a jury to see if there were videos and photos of them as a couple engaging in that same type of activity? How about a step further? What about the other females? The other females on all of this treasure trove of information, videos, and photos where they're also engaged in this kind of activity. Faces are covered. And there were some real victims here, okay? There were some real victims. There were, in fact, it was labeled as victim number 1, victim number 2, victim number 3, that they know were drugged. They know were actually raped. They know, the Attorney General's office knows about these victims, told them you don't have a choice but to testify. But after the smear campaign that took place with the media, all those tabloids that went out there, everything that Melanie Curtin fell under, where they blasted her everywhere as being a part of the children, do you really think these other victims really wanted to come forward now? They had gotten married since then. Their lives have changed. They have children. They wanted nothing to do with this. And they told the Attorney General's office, I do not want to testify. I do not want to be a witness to any of this. But they were told, you don't have a choice. We're going to subpoena you and you're going to testify. So much so to where these victims had to go independently, go get attorneys so that they can get themselves out of a subpoena to have no attachment to this case whatsoever. None of that information was allowed for the jury to be able to see. None of it. Okay? Again, I've already talked about the role playing. There were thousands of photos where wife number 2, the victim, and Denny engaged in these types of fetishes. She consented to these types of fetishes and continued to please her husband while doing these activities under video. So how can you sit there and say whether somebody consented or did not consent on a 17-minute video? I don't get it. There's also other things. So now I'm going to read to you what the court specifically said, and this is in the First Circuit Court of Appeals. They found improperly admitted evidence that unfairly prejudiced the defendant and improperly excluded other evidence. So it's not, Melanie Curtin tried to get some sort of defense. Again, the internet search history wasn't allowed in. The photographs or the victim number 2, or excuse me, the wife number 2, the victim in this case, well, we had just talked about all the photos and videos of them engaging with their head covered. That wasn't allowed in. But you know what they did? And this was allowed in the court, and this is what they're talking about, the prejudice towards Melanie. They allowed in, the Attorney General's office introduced at trial, videos of Denny Perkins and Melanie Curtin engaging in sexual activity. Specifically, there was a blowjob that took place in a department store. Melanie's attorney immediately objected to this, but the judge allowed that to become part of evidence and allowed it in, and it was showed to the jurors. There was also a car wash incident. So you have videos that have nothing to do with the said victim, has to do with Denny Perkins and Melanie Curtin, just the two of them, 2 consenting adults. But yet those videos were allowed to be introduced at trial. They were objected to. They were overruled. Judge allows them to come into evidence. Jury is able to see it. That also was something that the appeals court saw, didn't agree with. And, lo and behold, more evidence and more ways of Melanie not being able to defend herself is coming to light. You have, she's literally being smeared in the public eye. Starting all the way from the tabloids all the way through. Now you have video in your trial, in your trial that's introduced at trial that just shows you in such a negative light and you have no way to be able to refute it. But that wasn't allowed in. Find that to be incredibly interesting and very much disturbing. So I'm going to stretch this a little bit more because we've already talked about evidence that wasn't allowed in and things that she tried to do in order to provide a defense, which she was adamantly denied. The other disturbing facts in this case was that the victim, wife number 2, went on the witness stand under oath, said she has never engaged in this kind of activity before, would not ever consent to this type of activity. Yet, we find out about the oral lesson. For those of you that didn't listen to the show before, there was a party. Denny Perkins and his wife at the time, wife number 2, the victim, went into the back room. She starts performing oral sex on Denny. Her friend comes in. The friend then teaches her how to do it properly. However, the victim says that she felt disturbed by it, bothered, got up, and walked out of the room and sat there allowing her friend to finish off her husband. This is what she testified to under oath, that she would never engage in this type of activity. That's what we find. That's what's told. Not to mention, and some of this information was known during the pretrial. So how she was able to go on the stand and act like she's Mary Poppins making cookies for the neighbors that are coming in and, clearly does nothing wrong whatsoever, is able to go on a stand and give such a story like that. Come down to the new trial. This just happened within the last few weeks. The Attorney General's office knows, and it's my personal belief and opinion, that they know what they did was wrong. They know they set her up and they specifically did things to get Melanie. And now they know they're relatively screwed. That's just my opinion. But why do I say that? Because now you want to go ahead and file writs and you want to file motions to prevent the victim from being able to testify in public. You want the courtroom, everybody out, it's closed off, with the exception of the media. The media is allowed to be in there and they can report on it however they want. But everybody else would be closed to. Well, that's really unfair. It's unfair to Melanie Curtin because you have a right to come at your accusers. You got a right to challenge it. That's in the Constitution. Yet, that's initially what they tried. They want to keep that out. They also want to keep out the affidavit. They want to keep out the oral lesson. They want to keep out the internet search history. They want to keep out the photos, the videos, all stuff that they requested, just like they got it in there the first time. This time, not so much. The judge himself was found to have stretched his discretion, and guess what? The courtroom now has to be open. So everybody's going to be able to hear and see the victim testify to what their knowledge was of what happened back November 8th, 2014. She's going to have to answer to the oral lesson. She's going to have to answer now to what exactly took place. And, with her with her ex-husband, when she went through that divorce, she filled out an affidavit going all the way back to 2005. You're going to have to answer for all that. And a big question I would like to know, and I feel a lot of you would like to know as well, and I hope it gets asked. But I have a hard time understanding the investigator in this case. Hear me out. You're investigating a case. It is complex and it stretches hundreds and hundreds of victims. And you're spending so much time to try to identify them, and it's not an easy task. I understand that. But when you specifically bring this victim, wife number 2, into your office, and you're going to have an interview setting, you have to be prepared to ask follow-up questions. And the fact that that didn't happen, specifically, when the victim says, wow, Melanie doesn't look right. What do you mean Melanie doesn't look right? How is it that she doesn't look right? Is she under the influence of something? Is something wrong? How well do you know her? How do you know her mannerisms so much that you would know that something's wrong? But not one of those questions was asked. But how about the fact that as you go through all this information, it is now known to you as an investigator and by the words coming from the victim themselves, right? The said victim, wife number 2, with her knowledge of Denny Perkins recording her own daughter from a prior marriage, having a camera on a watch that was in the shower and recorded her friends, made very inappropriate comments, inappropriate touching. How about the fact that you know that Denny Perkins in the middle of the night got up, walked out of the room, over to where 2 teenagers are sleeping, and ejaculates so close that it's on the bed sheets, and you have enough wits to go out over there, help clean it up, and had this knowledge, and still did nothing about it. As an investigator, because I've been in these shoes before, and I've had to make this difficult decisions before of arresting parents or people that were involved in a crime. You are very much an accessory. You did not report it. You did not take it to law enforcement. You did nothing about this situation. Nothing. Other than allow it to continue. The grooming, it continued to go on and on. The recordings, you knew about it and still did nothing. It's as if you allowed this type of behavior to happen, and yet you weren't charged. I don't know why. You're an accessory. You are very much a part of it. And why you were not charged and held accountable is beyond me. And it makes me wonder again, my opinion, I'm going off on my own tangent here. But were you promised something? Were you promised something to not be charged? Maybe if you testified against Melanie Curtin? Because I'm going to make a correction here, because I did state in episode 1 that Denny and Cynthia Perkins pled before Melanie's trial. That's not the case. I was mistaken. Melanie Curtin was convicted before Denny and Cynthia Perkins pled guilty, which is clearly before the second trial. That hasn't happened yet, so I just want to correct that real quick. But what were you promised? Because you don't want to testify. You don't want to be a part of this case. You even found the phone while spring cleaning. Yet, here we are. And now all of this is starting to come to surface. You had no problem at all with, my opinion, an innocent woman going and doing life in prison without the chance of parole. I really want to understand that thought process. I really want to understand what happened there. Because as an investigator, I feel like I know pretty darn well what happened here. And I hope things get corrected this time around. I want to talk about something else that was withheld. We talked before about Denny Perkins being a high-ranked official within the sheriff's office. There were files, hundreds of files of women that Denny preyed on. He would get information on them. He would seek them out. He would build an entire database profile on them and use his law enforcement powers to get closer to them, to make them feel safe, and then eventually prey on them and use them. I want to also talk about the text messages. I just brought up something about it. Back on November 8th of 2014, the victim and Denny Perkins text messaged Melanie Curtin multiple times to come over to the residence. It was their marital residence. Melanie had let them know that she had a little something to drink earlier. She didn't know if she should come over or not because she had her son with her. They ended up convincing her to come over if it wasn't too late to watch a movie. It was 11:08 p.m. when she got that last text message before heading on over there. The next morning, at approximately 10:35 in the morning, the text messaging begins to continue. Except this time, Melanie Curtin is in the emergency department, as I've stated to you previously. There's a lot of texts that go back and forth. One of the things that came about from the appellate court when they decided to toss Melanie Curtin's case out had to do with some of the text messages. They didn't reveal all the text messages, just some of the text messages. Again, something important for the jury to be able to see, all the texts. Why are we trying to just give snippets, but not all of it? But they had no choice but to give some of it because this spring cleaning that the victim did and found this phone, just randomly found this phone right before the trial was supposed to start. Turns it on over to the attorneys or the investigators, and they've got to now go through it, which pushed that trial from springtime to closer to the holidays. My belief, she found that phone and turned it in because that was her way of trying to get out of it, hoping something within that would poo-poo the case altogether and throw it all out and everybody can go on their way. But that's not what happened. Instead, we're going to go through, we're going to find all these text messages, but we're only going to give some of the text message to the jury, not all of it. We are supposed to have all the evidence and have everybody see what it is on both sides. You can't create a bias within your case. That is not what our judicial system and our court system is built on. You have constitutional rights. You have a right to question your accusers, to face them. You have a right to a fair and impartial trial. These are your constitutional rights. Yet, in this case, didn't seem like Melanie Curtin had any rights. I don't feel that Melanie Curtin had any rights. How could she? She was smeared maliciously by the media. She was linked to being involved with the children. And Cynthia Perkins, some 6 years later, 7 years, she had nothing to do with any of that. Yet, there isn't a tabloid or a local news outlet, and hell, even some of the national news outlets had all of this information that she's the third person involved with Denny and Cynthia Perkins. She was guilty automatically from the public opinion. Still today, even since starting this podcast, there are people that will come out and say that she was involved with the children. Let her fry. But the majority of people have some brains and some common sense and decide to look into the facts of it and realize, you know what? Maybe she really didn't have anything to do with this whatsoever. Now that all the evidence is coming to the surface. You can't create a narrative and try to push just that narrative when you know you're withholding somebody from being able to get exculpatory evidence. What exactly is it that you tried so hard to push? What is it about Melanie Curtin that you worked so hard to relatively bypass the truth, exculpatory evidence, and let's just create a complete narrative of what we think may have happened so we can get a conviction? How would you like it if that was your family member? Probably something you didn't think about. Doesn't include what happened here to Melanie. What happened to Melanie is wrong. It is wrong on multiple levels. Smeared by the media. Won't allow the evidence in. You can't even get all the text messages. can't use Denny's internet search history, which was saturated with fetishes and things he was searching for, covering your face up while having sex, to role-playing unconscious. These are things that his wife number two, the victim, allowed and consented to and played along with her husband in doing. You don't allow that evidence in. You don't let the photos and videos in. But yet we're going to go ahead during trial and sneak in a couple of videos of Denny Perkins and Melanie Curtin getting it on in a department store dressing room. Because yes, that clearly shows that him doing something to this victim. You knew the intended purpose of that was to smear. And you did it, and you're very effective at it. But guess what? An appellate court thinks otherwise. The Louisiana Supreme Court thinks otherwise. Because that showed prejudice. That wasn't fair and impartial. That was a discontinuation of the smear campaign. You can't get any kind of defense. Can't even object, because anything that's objected to is overruled and allowed in anyway. Let's talk about the jurors. How about the juries when they went into the deliberation room? It's getting so hostile in there. People want to go. People don't care. They're over it. Yet they can't come up with it. They cannot make a verdict. They write a handwritten letter to the judge underlining "we cannot" and underline "cannot" twice. Gave that to the judge, and the judge sends them right on back in to deliberate some more. It's getting so hostile in there that one of the juror members punches the wall and punches it so hard with such a noise that the bailiff has to come in thinking that there's a fight going on. And then you have that one juror, juror number 3, who all along thought this was a role-playing and a fetish. It didn't make any sense. Yet he was belittled, bullied, ridiculed, threatened beyond belief. If he didn't change the way that he thought, then they were going to beat him up. He was subjected to physical harm. He was a Marine. He fought in Iraq. I don't consider anybody that's been in the military to be a wuss. And he felt that kind of threat coming, who ended up changing his mind and then immediately tells the juror, or the Melanie Curtin's attorney, calls Melanie Curtin's attorney and notifies him of what just happened in the back room while they were doing their deliberations. Ladies and gentlemen, that's called a hung jury. For those of you that don't know, okay? They really didn't have, and you can't force somebody to change. And that's what happened. Then he comes forward with it. They have open court on it on a Monday. Kick everybody out of the room. The Attorney General's office, Melanie Curtin's attorney, and the judge. And a short time later, the judge, it's already been ruled on. We're moving on. This has been a complete miscarriage of justice. I am usually one that likes to stand on the side of investigators, but I cannot and will not stand on the side of this one because I know it's wrong. And I know, my opinion, I think there's some serious malicious prosecution taking place here. I think deep down inside you have a case that's a handful of shit, yet you still press on anyway. And now you got yourself in a major pickle. So I'll be curious to see what happens in the coming months. But the evidence in this case does not hold the weight that you claim to put somebody away for life without the possibility of parole. I don't see it. I haven't seen a single bit of evidence that really shows me that that's where Melanie Curtin belongs. Not a single bit. Maybe the way that you presented the case in court and holding out the exculpatory evidence to fit a very specific narrative, maybe that's the only way that people could see it in through your eyes. But when the reality comes out and you put all the cards on the table, there's no way, there's no shot. Melanie Curtin is not a rapist. Melanie Curtin is a victim, and she's a victim of malicious prosecution. She was a victim of the media. She was publicly displayed, dragged through the mud. So was her whole family. For 6 years now, her life has been torn and turned completely upside down. She can't get work. She's got nowhere to go, where people don't recognize her. Her life was threatened countless amount of times right after all this had taken place and her smeared through the mud through the media. Her bail bondsman, life was threatened as well. All for what? It was a video involving a threesome. And again, in a 17-minute video, where do you see on there how it all started within the video, where they were able to consent, not consent? The video starts while the sexual activity is already taking place. And again, what we do know is there is an awful lot of history where you have this role playing and this fetish that continues to go on. There's plenty of that. Plenty of that. You now have your star and key witness, the victim, wife number 2. Oh, I can't wait to see her testimony. I can't wait to see what she has to say, saying that I would never engage in this kind of activity. I would never consent to somebody recording me having sex with a third party, any of that. Yet, all lies. Everything from your affidavit all the way through to your testimony, it's all shit, and you know it. So I hope that this case goes forward with being truly unbiased, and you can have a right to a fair trial. I hope that happens for Melanie Curtin, because she deserves it. And that trial is not going to come up in the spring. If there are any updates that come up between now and until the springtime when they announce the next court date, I'll bring it to you. And as I get more information, or as I gather, because I'm getting this information as it's submitted, or after it's been ruled upon, I should say, it's all public. And I'm going to dissect it, and I'm going to continue to bring you the facts on this case. The facts do not add up here, and I can't wait to see Melanie Curtin as a free woman without having to wear an ankle monitor, paying a ridiculous amount of money every month for her monitoring. Her case has been thrown out, yet she's still treated just the same. I really hope justice is served in the correct manner here. And I think you, the public, should do your own independent research into what it is that I'm telling you. It's public. You can find it. The transcripts are out there. Read it. Don't just take someone else's word for it. Read it. And when you read it and you go through it systematically like I have, you will find all the holes in this case. And you will find what I believe to be malicious prosecution, because that's what it is. Please share this case amongst everybody out there that you know that is into true crime, that really wants to see what justice is all about, what our court system is supposed to be about. Be on the side of Melanie Curtin. That's what I'm asking you for. Until next time, please like, share, subscribe. The Jim Rathman Show. You can follow me on Instagram, The Real Jim Rathman. You can follow Podgo and Hi Hello Labs in Orlando, Florida. I'll see you soon.